forward. The other important thing with termination is that at the end of a term, you can plan for it. Termination's coming up in 6 months. It's coming up in 3 months at the end of the term. You know, well, we need to get another supplier involved, or we need to bring this back in-house. But what happens if it suddenly terminates? So there's a termination for breach, termination for insolvency. Insolvency, you might get no notice. This goes back to what we said earlier on. You need that plan B. You need that plan B throughout. And this ties in with your BC and DR as well. But you need to understand that termination can happen at any time of the cloud arrangement. And some organizations don't think about that. They think about termination at the end of that 5-year contract. We need to do something. Well, that could terminate in 6 months. It could terminate in 3 months. What are you going to do when all your data's out there? So that's something that you need to be thinking about internally as to what you will do in those events. And again, the IT team are very well placed to understand practically what that means. Your commercial, your legal team won't know those things. Again, the reason for making sure that is fed into those streams. It's really about empowering the IT team to be more than just the IT team. They are, although they've got a very important function there, they've got a very important function in terms of the contractual arrangements as well. So those are some of the key legal aspects. There are the contractual issues as well. So payment profiles, for example, you know, how are you going to be paying? Is that going to be monthly? Is that going to be quarterly? Is it going to be annually? Is it going to be in advance? Is it going to be in arrears? How does that stack up with your cost model and the benefits you're looking to achieve? Intellectual property rights. We're advising on an arrangement at the moment, supplier side, where the customer said, right, there's going to be some bespoking, a very limited amount of bespoking. And they said, well, we want all the intellectual property rights. We want those intellectual property rights. We want to own them. And it was a very contentious issue for the customer. And having sat down with the customer and said, why do you want those? Well, we paid for them, so we need those, and you can't use those. And you know, that's really important to us, so we might use it elsewhere. When the technical teams got talking to each other, they actually found out, okay, there was some bespoking. There was no rocket science to it. And the bespoking was actually to the cloud platform itself. And they couldn't actually use that with any other organization. It was very specific to that cloud operator. So again, one should be thinking about, if you want to get to start this project, IT teams, commercial teams see the legals as a necessarily evil before they can get on with the work. Well, look at ways of minimizing that legal discussion. Flag to your team, yeah, there are IPR, you are going to deal with it in your contract, but by the way, we're not fussed. They can keep it, and that's fine. Because if you are looking to keep any IPR, you're going to get some resistance from the service provider. Might not mean anything to you because you can't use it elsewhere. And the service provider, if they do concede to it, they're going to charge you a premium for that because it means they've got to reinvent the wheel. Next time, they've got to do something similar for another client. The times to actually keep that IPR is where you can reuse it elsewhere, or if it is particularly sensitive from a confidentiality or a competitive perspective for yourselves and you don't want it being used with your competitors. There's other issues, Freedom of Information Act. So for public authorities, you might get requests for information. If your data and your information is in the cloud, you want to make sure there's a flow through to ensure that you can get that data, you can get that information from the service provider quite quickly. Step-in rights, again, something that lawyers sometimes get very excited about. I don't really, because I don't see the need for them really, especially in a cloud arrangement. You know, step-in can happen at 2 levels. It can happen at a management level, so you'll sort of take your supervisory role of what the individuals are doing in the supplier organization. The supplier will be reluctant for you to be doing that. Or it can happen at a more at an operational level, at a technical level, where your people are going in and they're taking over from the supplier. And again, it is a contentious issue, it is put into contracts, but it is rarely exercised because at an operational level, do you really want to be putting your people in or third parties people into the supplier's organisation to run it? Wouldn't it be simpler just to go to another supplier? And all the headache and everything else associated with that. Looking at management stepping in and supervising it, what a supplier will do if they do concede to it, will say, fine, you're coming in, you're saying you can do a better job of managing this and dealing with these issues than us. So when you're in, we're off the hook on service levels and everything else because that's your responsibility now. You're the one who's saying that you're going to take over this management control. So have a think if you are going to go down the step in and that's important to you, flag whether those kind of things are important in a cloud arrangement or not to yourselves. Subcontracting restrictions, if you wish to impose those, particularly in a private cloud, you've done your due diligence on the supplier, you're comfortable with them, but you don't want them subcontracting it to other suppliers unless you're sure and you're comfortable with them. So you can put in restrictions that any subcontracting needs to be with your prior consent, and that the supplier should let you know up front if there are any subcontractors that they need to use, so you can do your due diligence on those as well. And then, of course, law and jurisdiction. So people in this room will probably want their contracts under English law and English jurisdiction, because from an enforceability perspective, from a legal perspective, it's much easier to manage than having to deal with the laws of other countries. That hopefully brings us to the end of this session and gives you... My main aim today is, as I've said on the computing blog, is to let IT teams know they've got a much bigger role than just the internal role, and they have a big role in these commercial and legal negotiations rather than just being brought in at the end of it. They need to be integral to it, and they need to empower their team within their business unit to let the business unit know that they can provide some real value add here. Thank you. Any questions?
Most of the scenarios you went through were sort of greenfield, we're starting up there. What about where somebody in the business has already signed a deal with a cloud provider and it gets too big for them to handle, and then finally they call in the IT people to sort it out for them? Have you come across that? What's the best approach? Terminate and start again, or fight forward?
There's a legal word saying that the concept known as you're screwed at that situation.
Know that one.
But basically what's going to happen in that arrangement is it's going to come to the contract. You're going to want to pull out, you're going to say, well actually this arrangement doesn't work for us anymore. And the supplier's going to say, well, you're either locked in or, yeah, fine, we can negotiate a termination. And what you will normally do, if you are feeling that a cloud service provider that you're already in with, contract's not allowing you any rights, rather than saying, well, we can't get out of this, it's worth having a sensible conversation with the supplier to say, guys, you know we're too big for you, or you can't do what we're actually doing, rather than having a breakup because we know you're going to be in breach of service levels or you're going to provide a support service, and word's going to get out there. Why don't we have an amicable breakup and a controlled step down of this and a controlled migration, and let's discuss the termination costs to do this. Let's discuss the termination arrangements for this. And most reputable suppliers will do that. And again, it goes right back to the beginning there. If you've done that due diligence up front, you've got those reference clients from the supplier, they're more likely to have those kind of sensible conversations than someone who's giving you a cracking deal on the pricing, but won't then help you in these kind of arrangements.
Which is always the problem with the business. They'll be cost-driven rather
Yes.
than service-driven.
Just a couple around safe harbour. The first, I wondered if it's ever been sort of tested in court, there's any precedent around that. And the second part is, am I right in thinking that even if you're under safe harbour, there's actually still nothing preventing an American authority from subpoenaing your data?
So what was the last one?
If you're
Under
with
safe
an
harbour.
organisation under safe harbour, is there anything stopping your data being subpoenaed by an American authority?
That all falls within US law, because safe harbour is all a US aspect. So we tend not to get involved in those types of aspects. With regard to the subpoenaing, that will actually fall within that. And I know in the US there is legislation there which actually does allow you to subpoena and get access to that data. So from that perspective, yes, you are at risk on that. Most of the organisations that we deal with are B2B organisations where they are dealing with business customers, so that's lower risk. Where that's going to be higher risk is where it is a B2C arrangement, and that's where the subpoenaing to actually say, well, what is that content? What is that data likely to be? Sorry, your first question again?
First, I just wonder if there's any...
Not that I know of, but with safe harbour, you have to also bear in mind that just like with the data protection legislation, someone can say we're compliant. You can be safe harbour registered, but if you have actually a look on the safe harbour website for the registration, it actually says, by the way, most companies safe harbour, we don't give any, we don't say that they're a great company to go for, that they're fully compliant to anything else. So you still need to do all your due diligence. So safe harbour is ticking one box, but it doesn't avoid the need to still do the same degree of due diligence that you're doing in any event anyway.
Force majeure and BCD, what particular challenges you face? Because normally, your force majeure will sit within your normal T&Cs,
Yes.
and then you will normally negotiate your and business continuity separately. You flagged up that you need to be cognizant of the force majeure not impacting. What are the challenges?
So what one needs to, from an internal IT perspective, what you need clarity on is what actually is the force majeure provisions in the contract, and you need to understand what scenarios is the supplier getting off the hook on, and are you comfortable with those arrangements? Then on your business and what you will normally do and what lawyers will do is in the front end they will acknowledge that there are business continuity and disaster recovery obligations, whether they're in a schedule, whether they're incorporated by reference to some of the document. And what the provisions in the front end will actually say is that the force majeure provisions will not affect the supplier's obligation to still provide business continuity and disaster recovery obligations. Now, in order to do that, those BC and DR obligations need to be very specific. So it's quite clear that this is the scope. So if all these things happen which are beyond our reasonable control, then the BC and DR bit is as well, but this bit's safeguarded. You, the supplier, still have to do that. And that's the bit that needs to be clearly spelt out. But from a customer organisation perspective, it's making sure that the BC and DR is properly done in terms of the plan. And in terms of the force majeure, it's not going wider than what you feel is reasonable.